When you're lost in a world of legal war, you don't know which way to go. There's a hero waiting with expertise to lend. The Utah employment lawyer, HR's best friend.
Welcome back to HR's Best Friend, our podcast for HR professionals and business leaders who want to make sure they stay compliant and don't get in trouble and keep their employees happy. D. Scott Crook is the Utah employment lawyer. He's consistently listed in Rocky Mountain Super Lawyers and Best Lawyers in America. He is the managing partner of Crook Legal Group. Scott is only licensed to practice law in Utah and Idaho. He's not giving specific legal advice. This shouldn't be construed as legal advice for your problem. If you need specific legal advice, please go to an attorney, preferably this attorney. All right, we got through the boilerplate intro. So we've been gone for a while, mostly for two reasons. One, at the end of April, we were focused on putting our Utah employment law legislation seminar together, which was great. And the other reason is my wife and I just added our third baby to our growing collection. But now we are back, hopefully on a regular cadence. Today, we are converting that employment law legislation seminar into a podcast episode. So it is long, it's an hour plus. But if you are an employer, especially an employer with governmental ties, you will want to listen to all of this. My dad, Scott, and Carolyn Howe, our associate primarily focused on employment law, did hours and hours of research to help prepare you for all of these new laws that the Utah legislature has thrust upon you. So with that, let's dive into this episode. It'll sound a little bit different than our normal episodes because it's a converted webinar, and you won't hear me again, but you'll hear Scott and Carolyn now. Thanks.
Today, we're going to be talking about legislation. Carolyn Howe is with me. I'll let her introduce herself when the time comes for her to explain or do her presentation. But before we get to that, I want to talk a little bit about the legislative session. Today, we're talking only about Utah state legislation. We know that there have been some interesting national developments in the last couple of days, one of which, of course, the whole world is afire over, which is the Federal Trade Commission's new rules on non-competition agreements. We won't be talking about those today, but we're certainly aware of them and know that you have about 120 days before the rule goes into effect if you have non-competition agreements, and we can certainly talk about those individually. My best guess is that rule is not going to be implemented, that there are going to be cases. In fact, 2 cases have already been filed in Texas, and it's likely that the rule will be stayed during the litigation. Also, there have been new rules over overtime salary beginning in July. In July of this year, there's going to be a new overtime salary threshold of $884 per week. And again, we're not going to talk about that today, but we're aware of those things. So we're going to talk today about the Utah legislative session of 2024. For those who aren't aware, the legislature in Utah is a part-time legislature. It's only in session for 45 days. This year it was between January 16th and March 1st. But don't be fooled. You can pass a lot of legislation in 45 days. In this case, there were over 591 pieces of legislation that were passed, which means there were a lot more that were considered. Of those bills and resolutions, 72 of them affected employers in Utah. We have provided and will provide to all our participants an outline of all 72 of those particular laws that were passed. Some of them will be relevant to you, some of them will not. A lot of them deal with state employees. We'll talk about that briefly on a couple of pieces of legislation, but today we're focusing on 14 pieces of legislation that we believe are significant. And so Carolyn Howe will start, and she will be discussing 7 of those pieces of legislation, giving you an idea of what they are, what the key takeaways are from them are, and any questions that may arise from them. And so I'm going to turn the time over to Carolyn right now for her to do her presentation.
All right, hopefully everybody can hear me all right, not just here in person, but online as well. Hello, I'm Carolyn Howe. I'm an associate attorney here at Crook Legal Group. I have an undergraduate degree in English with a minor in history. I have my JD from S.J. Quinney College of Law at the University of Utah. This is my 2nd year of practice, and I'm happy to be here with you all today and presenting here with Scott, and giving you all some updates about this year's legislative session, and in particular the bills that have been passed that affect business owners, and as well as public entity employers as well. All right, if we want to start the slideshow, James. Oh. Okay, I just can't see the presentation, so I'm not sure where we're at. So okay, so we are on, starting with a little bit of a spicy topic to get us nice and awake this morning. We're going to talk about bills that involve weapons and firearms. So let's move on to the first one, which is House Bill 84, called the School Safety Amendments. So House Bill 84 creates something called the School Guardian Program. And this is a program where a volunteer school employee can store their firearm in their office on the school grounds. The interesting thing is this particular program excludes specifically, principals, teachers, and those whose primary responsibilities involve classroom instruction or, interacting with students. But we'll get to that in just a little bit. There's another bill that fills in a little bit of a gap there. So a school guardian can store their firearm in their office on school grounds if, 1, firearm is stored in a biometric gun safe, and 2, that school guardian is physically present there on the school grounds while that firearm is being stored. Now, they cannot open carry these weapons unless there's an active threat going on at the school. To be eligible to be a school guardian, this employee must complete an initial training within 6 months before joining the program. They have to hold a valid concealed carry permit. They have to certify to their county sheriff that they've completed their training, and they have to successfully pass a mental health screening check. Every year and twice a year, there are trainings that these school guardians have to go through to maintain their school guardian designation. So based on House Bill 84, what should schools and school districts be doing? First of all, evaluating, do they want to be involved and create a school guardian program? If they do want to participate, reviewing and updating safety policies and procedures to incorporate the school guardian program. And something I think is really important is communicating with stakeholders, parents, students, the staff at the school, and talk about implementing this school guardian program. All right, House Bill 119.
Carolyn, I forgot to say something. Go ahead and you can tell people. If they have questions, be sure to online also. If you have questions, please submit them online, and then we can also we can respond to them as we go. So don't feel like you have to wait until a later time. We will take questions at a later time, but if you have specific questions, we have somebody monitoring the online thing, and also we can take them from the audience. So I just wanted to make sure that you knew that.
But we can also do a Q&A at the end. So if you don't think of something till the end, that's fine too. So House Bill 119, this is similar to House Bill 84. This one is called the School Employee Firearm Possession Amendments. And if you recall, House Bill 84 was about non-teachers and people whose duties were not primarily student interaction or instruction. Well, this bill is particularly about teachers, and it allows teachers to store their firearms in their office or in their classroom on school grounds if it's stored in a biometric gun safe and the teacher is physically present there on the school grounds while the firearm is stored. Similar to House Bill 84, teachers cannot open carry their firearms unless there is an active threat at the school. Teachers have to complete an initial training within 6 months before joining the program. They also have to hold a concealed carry permit that's valid. They have to meet training and permit requirements. The teachers have to undergo annual classroom response training and comply with any safety rules that are established by the Department of Public Safety. So between those two bills, we have pretty much all personnel, employees at the school kind of covered between those two. So kind of building on the key action points we talked about with House Bill 84, House Bill 119, we're going to add to that list. And, you know, teachers or maybe the school guardians who want to participate in these programs that have been created, you know, schools and school districts should make sure that they understand and, you know, are complying with the regulations that are outlined in House Bill 119 and 84. You know, I think it's really important to establish communication and coordination channels with local law enforcement so that law enforcement knows who's participating, who are the teachers, who are the school guardians, so that they're aware of who those people are. And I also think it's important to, you know, solicit feedback from the people who are participating, those teachers, those school guardians, community members, parents, students, and, you know, open that dialogue so that you can identify areas for improvement as these programs are implemented. House Bill 84 and 119 kind of leaves some unresolved or maybe lingering questions. Like, for example, who's supposed to provide this biometric gun safe? It doesn't say, right? Is it the school? Is it the person who's participating? So like the teacher, the school guardian? Is it the school district? It's not really clear as far as that goes. But maybe there are some more social questions that we should be asking, you know, with what might be the long-term effects of implementing these programs at schools. Like, how's it going to affect school culture, you know, the community dynamic, maybe even student well-being. These are things that we'll just have to see how they play out as these programs are implemented going forward. I'll pause in case there's any questions so far about HB 84 119. Right. So our last bill that kind of addresses the weapons category, it's House Bill 369, called the Defensive Force Amendments. And we're all kind of familiar with, you know, you can use deadly or defensive force to, you know, protect yourself, right, from an attacker. Well, kind of along those lines, the Utah legislature has broadened that and says that an individual is justified in using force against someone who unlawfully enters their place of business or employment. But I mean, you can't just go out there and Rambo it. There are some, you know, some caveats to that. You have to reasonably believe that this person who's entering your business or place of employment is coming there to commit a felony of some kind, or they're there to assault somebody and hurt them physically. And that person has to be there, like, in your place of business or employment. But you also have to reasonably believe that the force is necessary to prevent this person from committing the felony or from committing the assault that you think is going to happen. So those are some of the, like, little contours that come in with this particular defense that can be raised. All right, so House Bill 369, there are some key takeaways for businesses and employers. review, and maybe you might need even to potentially update your policies and procedures about security and how you respond to, unlawful entries or an attack to your place of business. Provide training to your employees about how to respond to situations where defensive or deadly force might be necessary to prevent, these kinds of attacks and unlawful entries. And then I also think, businesses should establish protocols for how to document and report these incidents that involve the use of force. All right, that's the end of the weapons section. I'll pause again in case there's any questions about any of these three bills we've talked about so far. No questions so far. All right. So hopefully we're all awake after learning about some weapons, exciting. So the next kind of broad topic that I want to touch base on, there are a couple bills that affect wage, pay, and hours. The first of those is House Bill 271. That's called Law Enforcement Employee Overtime Amendments. Just to take a little quick step back, there's a federal law, the Fair Labor Standards Act, and it says that certain people have to be paid overtime. Those people are called non-exempt employees. And then there's another category that don't need to be paid overtime, and those are called exempt, meaning they are exempt from being paid overtime. So this House Bill 271 requires the state of Utah to compensate its exempt employees for the time that they work over their normal hours. So even though federally they're not required, they're exempt from overtime pay, the state of Utah has said, hey, Utah, like employees of the state of Utah, need to be compensated for overtime. And how is that done? Our legislature has said by providing 1 hour of time off for each hour of overtime worked. Unless, the director of the particular division of the state that you work for, grants an exception because of work circumstances. Of course, there's always caveats, right? And so what that means is, exempt employees' work period is considered 14 days, comma, an 80-hour payroll cycle. So anything worked in excess of that employee of the state has to be provided 1 hour of time off. So you work 82 hours in a 14-day work period, you get, 2 hours off. The other thing that HB 271 deals with involves cities and counties, so something that may be a little more relevant. It permits, meaning this is a may, not a shall or a must, a may. Cities and counties may create or adopt, might be the better word, an ordinance that allows non-exempt employees who are engaged in law enforcement activities to be compensated at time and a half for their overtime. There is, of course, always the exception, and the legislature has said that counties that are subject to the Peace Officer Merit Systems in Counties of the First Class Act are exempt from this requirement. That's quite a mouthful of an act, but there is that exception that counties where that act is applicable, they are exempt from having to pass that kind of ordinance. So what are some key actions for cities and counties based on House Bill 271? Review your existing policies to look at your overtime compensation, particularly for these non-exempt employees who are engaged in law enforcement activities. If your city or county wants to adopt this ordinance to provide that overtime compensation, you should be assessing your budget to see what kind of impact that might have on it. And then, establish your procedures to make sure you're accurately documenting and tracking the overtime that these non-exempt employees are accruing. The next bill we're going to talk about is Senate Bill 248, called the Permitted Occupations for Minor Amendments. So this is something that should perk your ears up if you're an employer who hires people who are under the age of 18. This particular bill modifies the working hour requirements for those minors who are 16 and younger. These particular group of minors, those who are 16 and younger, they can't work more than 3 hours in a school day. They can't work more than 18 hours in a school week. They can't work more than 8 hours in a calendar day. They can't work more than 40 hours in a calendar week. They can't work before 7 a.m. and they cannot work after 7 p.m. So those are the new kind of hour contours for those 16 and younger. This bill also amends certain occupations that are permitted for minors, like those who are now 10 and older are allowed to deliver newspapers. And then certain agricultural occupations are okay for those who are 12 and older. This bill also amends exemptions for permitted occupations that have no specific age limit associated with them. So that's things like performing in a film or TV or theater production. So based on Senate Bill 248, here are some key actions that employers should be taking with regards to, employing minors, specifically those 16 and younger. Make sure you're providing training to supervisors or whoever it is that does your scheduling to make sure that that scheduling is complying with these hour, the contours of these hours that have been outlined. You may even want to provide some training about, the hiring of minors as well, and make sure you're putting into place systems that accurately track the hours, and not just the hours, but like the particular hours that minors are working. So what time they clock in, what time they clock out, for example. And that's just preventative, right? To make sure you're not violating these hour restrictions that are going into place with Senate Bill 248.
Can I make a comment?
Yeah. Hang on, just a second. Pass the mic.
So this is an interesting development. In fact, we have assisted some of our own clients in their, after COVID, and during COVID, there were lots of restaurants, for instance, who were sort of stuck in trying to find people who they could actually employ. Because the employment pool is low, and there were lots of restaurants who were just trying to stay in business. And some businesses in Utah were getting in trouble because they would do a search on the internet and to see what the requirements were for employing a minor, and the state law was inconsistent with the federal law. And in fact, the state law was more permissive than the federal legislation. And what ended up happening is some employers, in good faith, thinking they were complying with the law, were complying with the state law, but they were out of compliance with the federal law. And so this legislation appears to have been, it was probably something brought to the attention of some legislators who were responding to that. And now much of the state law is similar to what the federal law requires. Now you still, just as a precaution, even if state law allows something, you still have to look at federal law to make sure that you're complying with federal law, because even if you're complying with state law, you may be out of compliance with federal law. So I just wanted to note that based on recent events.
Thanks, Scott. I think that's really good to note. There's two different levels of law going on here, state and federal, so we got to make sure, we're being compliant with both levels. Another category of bills I want to talk about affect public entity employers. So I'll just touch on a couple, and I know Scott has a few that he'll cover in his portion of the presentation. The first one is Senate Bill 91, the Local Government Officers Compensation Amendments. And what this bill does is says that before a city or a county's legislative body can approve a budget that includes a salary increase for an executive officer of that city or county, that legislative body must first conduct a public hearing on this proposed increase. So that means allowing people to make comments about it. The legislative body is required to publish notice of this hearing at least 7 days in advance. And the public hearing must be held separately from any other hearings, but it can be scheduled on the same day if necessary. I thought of, if your city has city council on Tuesday, you can have your regular city council meeting, but either before or after the city council meeting, have a public hearing about proposing a salary increase for executive officers. So based on Senate Bill 91, cities and counties should make sure that you are scheduling the public hearings for these proposed compensation increases. So not just public meetings, but a public hearing. Make sure you're following publishing notice requirements. Make sure you're giving that 7 days advance notice for the public. Maybe you need to update some internal policies and procedures to reflect these new requirements. So those are things cities and counties should keep in mind based on what Senate Bill 91 has said. Senate Bill 91 did leave kind of some unresolved or maybe lingering questions for myself, kind of about transparency, like how does that come into play? Will or even should the rationale behind these pay increase proposals, should that be shared publicly or disclosed? That's just something we'll just have to see going forward. And then the other one I wanted to touch on as far as public entity employers is Senate Bill 174. This is called the Safe Leave Amendments. I'm sure we're all familiar with sick leave, vacation leave, bereavement leave, things like that. Well, this bill creates for state employees a new type of leave called safe leave. And this is the kind of leave that the state must provide to an employee up to 1 week per year for a reason related to or arising out of incidents related to domestic violence or sexual assault. The time off is, maybe spent, maybe you need to temporarily relocate. Maybe you need to go to the police department and, file a complaint. Maybe you need to meet with the prosecutor of the case. Maybe you need some counseling or medical treatment. The leave is for those types of things, just to help these employees, improve their health and safety. But it's not just the employee who has to be impacted, an immediate family member like a child or a spouse. If a sexual assault or domestic violence impacts them, the employee can take time off to assist that immediate family member as well. Again, this is for state employees, so those who are employed by the state of Utah. It prohibits, the employer from retaliating against an employee who uses safe leave. It does say that employees must exhaust all their other accrued leaves before using safe leave. It also says that employees are generally required to provide at least 7 days notice before using safe leave. And it also notes that safe leave does not carry over from year to year. So it's a use it or lose it type of situation. So based on Senate Bill 174, divisions of the state of Utah should look at, reviewing and updating their existing leave policies to incorporate safe leave provisions. Make sure they're clearly communicating and training employees about these new safe leave policies that they're enacting. Talk about eligibility, how it's used, the notice requirement, things like that. But also make sure to provide training to the HR personnel and staff on how to administer safe leave and also how to handle requests for safe leave that come in. Now, Senate Bill 174 left some lingering questions for myself, such as, when you request safe leave, do you have to provide some kind of documentation or proof? If so, what kind? If you're sharing this very sensitive, confidential, private information with HR, how should the HR personnel or staff be handling this sensitive information related to this employee's situation. The bill mentions, there's this 7-day notice requirement, but are there exceptions for situations where maybe advance notice isn't practical or even possible to give? Those are things that we'll just have to see how they play out with the implementation of Senate Bill 174. That's kind of the end of that category. I'll pause and see if there's any questions people might have about public entity employers in those two bills that I've talked about. No questions. Okay. And then the last thing I wanted to touch on was just a trend that Scott and I noticed as we were reviewing all these hundreds of bills from our very active legislature. And that trend I kind of categorize as family support in the workplace. House Bill 75, it's specific for state employees and their paid leave. It extends parental leave to include bonding time with a child or with an incapacitated adult. It allows parental leave for state employees who are fostering a child. In addition, it extends postpartum recovery leave eligibility to people who have their child at 20 weeks or greater gestation. Another bill that provides family support in the workplace is House Bill 192. It pertains specifically to local education agencies and their paid leave. It says that these local education agencies must establish paid leave policies for parental and postpartum recovery leave. It also creates and allows for employees who are in the same school or the same local education agency to share their leave amongst each other. So maybe you don't need the leave, but you have a colleague who's had a child and you want to share. House Bill 192 allows people in the same school or local education agency to do that. And then finally, House Bill 431, this concentrates on teacher retention because as we know, there is a crisis where teachers are leaving the field, and this is one way that Utah's legislature is trying to help address that is by mandating that local education agencies offer paid postpartum recovery leave to those who are eligible. This doesn't get implemented and become law until July 1st, 2027. So we've got a few years for school districts and local education agencies to get that figured out. But the goal of that bill was to, support teacher welfare and try to retain teachers in that field by offering them this paid postpartum recovery leave. So that's a wrap for me on my portion of the presentation. Again, we can pause for questions, but thank you so much for letting me share this with you, and I'll turn the time back over to Scott for him to present on his portion.
Well, thank you, everybody. We are going to take a short break now. About how long should that break be? About 10, 15 minutes? 15-minute break. Yeah, we'll come back around 10:30-ish. While you're just as a highlight, I'm gonna be talking about some of the legislation that involves some discrimination and equal opportunity amendments. Also talking about changes in drug policies that will be important. And so these are some of the more controversial bills that were passed by the legislature and will have some substantial impact on employers in the state. And so if we could take a break now, we'll be back at about 10:30. And we hope you can join us and we'll talk about some exciting new bills. Thanks. All right, well, welcome back. Thank you for sticking with us. Carolyn has gone over some of the legislation that involved weapons, work pay and hours, and public entity employers. Of course, we're going to now talk about, I'm going to spend some time now talking about some legislation that was a little bit more controversial, stemmed out of, recent national events, clearly, and there was a reaction within the legislature to that. So we're going to start. We're going to start now talking about some legislation that involves discrimination or equal opportunity, and we'll start with House Bill 55, which is employment confidentiality amendments. Interestingly, this bill enacts provisions related to sexual assault and sexual harassment in the workplace that applies to employers of any size. So what the legislation does is it says that if you are going to enter into any kind of settlement agreement or any type of agreement that relates to claim of sexual assault or sexual harassment within the workplace, that you cannot enter into a non-disclosure or non-disparagement clause related to those particular issues. So you cannot have a provision that says that precludes an employee from discussing their sexual assault or sexual harassment at the employer as a condition of that agreement. Now, there can be other provisions in the agreement that an employee agrees not to disclose, and you can require that the employee enter into certain types of non-disparagement agreements, but they cannot involve sexual assault or sexual harassment allegations. The other carve out is, for instance, you can make provisions for the non-disclosure of the identity of the victim. So if the victim wanted to make sure that their identity or his or her identity was not disclosed, then you could have those provisions. And it provides that a person who attempts to enforce an agreement that violates the legislation, that they will be liable for costs and attorney fees if they do try to enforce that agreement in court. So there's some interesting things about this legislation. One of the things is that even though the Utah Anti-Discrimination Act and the federal Title VII, which is generally applicable to sexual harassment claims, they generally only apply to employers who employ 15 or more employees. But this legislation applies to any employer, so it doesn't matter the size of the employer. The other thing that's interesting about it is that it has a non-retaliatory provision within it, which says you can't retaliate against an employee who alleges sexual harassment against the employer. And what makes this particularly interesting is that Title VII would not apply in that particular instance, or the Utah Anti-Discrimination Act would not apply, because there could be an employer that employs less than 15 employees. But what this means is that now all employers have to have anti-retaliation provisions for sexual harassment, even though an employee who may suffer sexual harassment at work for an employer who employs less than 15 employees, that employee won't have a sexual harassment claim under Title VII or under the Utah Anti-Discrimination Act. Yeah, question. Okay.
From Kim Baker.
Okay.
She asks, what if an employee makes knowingly false allegation?
Okay, so we have a question about what if an employee makes a knowingly false allegation. And this, the statute itself does deal with that issue, and it says that employees who do make knowingly false allegations will be protected by the Act. But you have to be extremely careful in those situations that you make sure that if you're telling employees that a knowingly false allegation will get you in trouble, that isn't considered retaliatory, because that itself may discourage people from reporting, because they may say, well, what if I can't prove it? Generally, under Title VII and under the Utah Anti-Discrimination Act anyway, a knowingly false allegation would not be protected, but it's a very sensitive issue. You have to be very careful, and you have to have very good evidence that somebody is actually falsely accusing someone else before you take any action against somebody. It's very tricky. Does that answer the question? Any follow-up on that? All right. Okay. So here are some key actions that all employers should take. Employers should review all of their template settlement agreements and severance agreements to make sure that they comply with the statute. This shouldn't matter to settlement agreements that occur with relationship to other types of discrimination, but if there's an allegation of sexual harassment at all, you need to make sure that your templates provide the right carve out. Secondly, all employers, regardless of size, should update their policies to prohibit retaliation based on a claim of sexual assault or harassment, or a claim that a proposed agreement violates the statute. So let's say the statute actually says that you can't be retaliated against, you can't retaliate against an employee if they complain that your agreement violates the statute. So that's an interesting element of it. And finally, there's this real interesting quirk at the end of the statute itself, and it says that the statute is actually retroactive to January 2023, which means that if this is true, if this is enforceable, any agreement that was entered before after January 2023, but before this legislation was passed, would be void under, and it had a non-disclosure agreement for a sexual harassment claim, would be void under the statute. And if an employer tried to enforce it, they would be subject to the penalties under the Act. So the question there is, and this is an unresolved question, is that constitutional? Is that something that will be enforceable under the Contracts Clause or under the ex post facto provisions of the federal Constitution and the state constitutions? So interesting development. So any other questions about that statute? Okay, so the next statute is HB 261, and it's the Equal Opportunity Initiatives. And this was clearly a reaction to a national uprising over DEI initiatives, diversity, equity, and inclusion initiatives, and also was a reaction to local news reporting about the University of Utah and other Utah State institutions of learning that required people to, or that was alleged to require people to agree to certain DEI goals when they became employed by the universities. And so this actually only applies to governmental employers, including cities and states, local government entities. And what it does is it prohibits the public educational institutions and governmental employers from requiring an individual as a condition of employment to submit or articulate their position on differential treatment based on an individual's personal identity characteristics. Race, color, ethnicity, sex, sexual orientation, national origin, religion, or gender identity. So this was a direct I guess, response to the controversy surrounding the higher education institutions in Utah. And this says you cannot, a governmental employer cannot require that as a part of employment. It also prohibits public educational institutions and governmental employers from requiring attendance at training that promotes differential treatment. In other words, based on individuals' personal identity characteristics. So you cannot require somebody to go to DEI training if, as an element of DEI training, they submit that one race is better than another, or a person's race makes that person more blameworthy than another. And then it also prohibits implementing or promoting policies or initiatives that discriminate against individuals based on their personal identity characteristics. Now, the problem with this legislation, and what they understood, the legislature clearly understood, was that certain federal grants, certain federal laws require compliance or require a grant receiving institution to identify affirmative action goals and also DEI initiatives as a condition of the grant. And so the legislation outlined exceptions to those provisions for compliance with state or federal laws or for federal grants. So what does this mean for governmental institutions? And the key actions that government employers have to take before July 1st of this year, and that is that they should review all employment policies and materials for violation of the statute. Now that means you have to go through every single thing that you have produced, including your employment applications, every training slide that you produce, everything that you've done, you have to review to make sure that there isn't anything in there that could be a violation. The second thing is, before you can send anyone to training off-site, you have to review all the material and courses to ensure that there is no violation. Because if you do send somebody to training and that training has a component of it with DEI in it, the statute says it's illegal for the governmental employer to send an employee to that training. The third thing is you have to eliminate any office or position that has been established with that as a goal. In other words, an equity office or position, for instance, that would have as its goal certain affirmative action steps. And the thing that is what this legislation is, and I would say arguably is the most onerous for small government employers, particularly those who are intergovernmental entities who receive mostly grant funding, is that they're okay. They can perform under their grants and they can comply under the grants, but they have to report all federal grants to a particular state agency that require practices prohibited by the Act. So although the entity can perform under the conditions of the grant, the federal grant, this legislation requires all grant receiving entities to identify every single grant that has a condition, something that would potentially be a violation of the Act. And for some governmental entities, that's going to be a very onerous duty, particularly those who receive most of their funding from grants. So that's that. Any questions about that statute? All right. HB 396 is the next statute we're going to talk about, and that's the Workplace Discrimination Amendments. This prohibits an employer from compelling an employee to communicate or otherwise act in a manner that violates that person's religious beliefs, sincerely held religious beliefs. And it provides a process for an employer to accommodate an employee's religious liberties. I'm not sure if this arose from the recent United States Supreme Court decision that changed the standard for religious accommodations under Title VII. The United States Supreme Court, in a recent case decided last year, changed the standard for determining whether there was a burden on a business from a de minimis standard, which meant a business only had to show, well, we don't have to accommodate this accommodation for a religious reason, if they could show any interference with their business functions. It just had to be de minimis. But the Supreme Court changed that and said, no, you have to show more than a de minimis impact. You have to show a significant impact. And that's what HB 396 essentially codifies that standard, although it is a bit different from what the United States Supreme Court required. So for the most part, in order for employers to be compliant, these are some of the things that employers should do. First of all, they should, this will only be applicable to employers who are subject to the Utah Anti-Discrimination Act and Title VII, which means employers who employ 15 or more employees. They should review their policies to assure that they meet the statutory standards. And for the most part, you're probably not going to have to make a lot of changes in most policies, but sometimes policies are would talk about a de minimis standard. Those aren't the best policies, but if your policy does say that, you need to make a change. And the other thing is you need to train all supervisors about the requirements of the Act. In other words, if the supervisors in the past have had to deal with religious accommodation requests, you should train the supervisors so that they know that they now have to meet a more significant standard before they can deny a request for accommodation. And a lot of those, for those who don't deal with this a lot, have to do with like scheduling. Like for instance, certain members of religions have different days of worship, and therefore they don't want to work on, perhaps like Seventh-day Adventists will ask for accommodation to not have to work on a Saturday rather than a Sunday. Or some dress and grooming standards are also a big deal when it comes to religious accommodation, because some people, for instance, an employer may have a prohibition against wearing hats, and there may be some religions that require wearing a particular headdress. And as long as there's no safety component to that, then you'd have to accommodate that request. So those are things that generally will arise. And then this, the next act we're going to talk about is HB 460. This only applies to governmental employees. And this is a real doozy, actually. Not that I'm complaining about legislation, but this can require a significant change for employers, governmental employers, and that is this. This legislation requires a governmental entity to grant an employee's request to be relieved from performing a task that conflicts with the employee's sincerely held religious beliefs or conscience if granting the request would not place an undue hardship on the governmental entity. And you can think of situations, in fact, there's a situation not super recently, but after the United States Supreme Court ruled that it was unconstitutional to prohibit same-sex marriage. You'll probably remember a few years ago, there was a case in which a clerk in a rural county in a state, not in Utah, refused to grant marriage licenses to same-sex couples and did so claiming that it was a violation of her First Amendment right to exercise her religion. This is probably the impetus of this legislation, although I cannot know. But that's where a circumstance might be where an employee of a governmental entity says, hey, I cannot perform this function because it will violate my religious liberty. So HB 460 says that you have to grant that request unless it places an undue hardship on the governmental entity. And it, some of the exceptions that would be considered undue hardship are if you needed to train somebody to do something, if you needed to do safety, if it related to safety or public safety duties. And the statute actually provides a process that an employee must follow to request the relief, and it gives some particular timelines that must be followed. And it also creates protections for employees who request the relief. And it also gives them a private right of action against the government entity who fails to give them the relief they want. So what are some key actions for governmental employers that they should take? Well, one is that you need to train all supervisors about the requirements of the act. And although the statute itself is self-executing, you don't have to, no governmental employer has to create a policy. It does permit a policy to be created that has the key elements of the legislation. And so the governmental employer should probably evaluate whether it's advisable to adopt a separate policy. So those are some key actions. And then finally, and this is similar, this is sort of similar to the previous act, and that is SB 150, and that's that provides generally a state statute that prohibits any governmental entity from substantially burdening any person's free exercise of religion unless the burden meets two requirements. This is a general prohibition against any governmental activity that would harm religion. But the breadth of the policy is such, or the breadth of the legislation is such, that it almost certainly applies to any action or any personnel policy enacted by a city or local government or by any governmental agency. And so there is really no action item other than just need to make sure that you evaluate your policies in light of that statute that was passed. It shouldn't really be that significant of a burden simply because this act actually implements it's a statutory exercise of a constitutional right that's already been established. Some unresolved questions of Senate Bill 150 is, does it really specifically apply to personnel policies or not? And that would have to be tried, but I would suspect that it does. All right, so now we're going to turn to drug policies, but before we do that, just wanted to pause for a second to see if anyone had any questions regarding any of those items of involving discrimination. No questions. What's that? Yeah. So the comment was, we probably have more private employers than governmental employers listening, and therefore there may not be as many questions about some of that. Now we're going to talk about drug policies, drugs themselves. And I would just key on this fact too. These also only apply to governmental employers. SB 233, which deals with the medical cannabis amendments. For those who don't know, Utah, of course, does allow medical marijuana. Okay. We do have a question. It's coming from online and we're waiting for it.
She says, if we are a qualified entity under the law, less than 15 employees, would that apply to this?
So the question is, if they're a qualified entity having more than 15 employees.
We are a qualified entity under the law, less than 15 employees, would that apply to us? She's talking about
HB 396. No. So HB 396 is an amendment to the Utah Anti-Discrimination Act, which only applies to employers that have less than or more than 15 or more employees. It also applies to governmental employers, but it does not apply to any other employer. So a governmental employer or an employer who employs more than 15 employees. So it would not apply it would not apply to anyone else. Okay, so now let's look at drug policies. So a few years ago, Utah established established that medical marijuana was permitted in particular circumstances. And as part of that legislation, it prohibited governmental employers from taking disciplinary action against employees who were validly prescribed medical marijuana, and they were to be treated identically to those to be treated identically to any other employee who had a legally prescribed medication. The act therefore protected governmental employees from action, but it specifically did not apply to private employers. So private employers can still take disciplinary action against an employee even if they have a validly prescribed medical marijuana prescription. SB 233 amends some of the provisions applicable to governmental entities, and now, before a governmental entity can take action against an employee for validly using prescribed medical marijuana, the employing agency has to do two things before they can discipline somebody for violations of that act. One is it has to consult with its attorney before taking the discipline. And the second thing is it has to obtain approval from the mayor or a county executive before it can take any employment action. So the interesting thing about the statute is that it actually provides more protections to people who take medical marijuana than it provides to people who take other legally prescribed medications. So, for instance, to give you an example, if you, for instance, were prescribed Percocet by your doctor for pain, and you did a drug test, and Percocet showed up on your drug test, and then the employee submitted to the medical review officer their prescription of Percocet, but for instance, the blood test or the test showed concentrations above the prescribed level, and therefore you failed the test. Okay. An employer could fire you, a governmental employer could fire you for a failure of the drug test, assuming it complies with the policy. And it would have to do nothing else besides see that you failed. Under this new legislation with medical cannabis, same circumstance. You go and you do a drug test. So an employee goes and does a drug test. Employee has a medical marijuana card. It submits that medical marijuana card to the medical review officer. Medical review officer can tell that based on the concentrations in the employee's drug test that it exceeded the dosage and therefore failed the test. The employer cannot fire that employee yet. The employer has to first talk to its attorney, and it also has to have the mayor or the county executive sign off on the termination. So a person with a medical marijuana card actually has greater protections than other people under drug policies. So what are key actions for governmental employers? First, you should evaluate your personnel policies to assure that they don't violate the act. Second, you should train all personnel involved in drug testing about the new requirements. And third, you should train the mayor or a county executive about their obligations under the act. And it's very important that you do this so you don't have any violations. And then, well, I won't say what I was going to, well, I will say it. And then because I think this policy is bad, I think you should talk to your legislator and ask them to amend the statute so that it treats everybody consistently. But that's another discussion for another day. Okay, any questions about that? Okay, and now finally, HB 411, which is the Local Government Entity Drug-Free Workplace Policies Amendment. That's a mouthful. So to understand this legislation, you kind of have to have a little historical background. There are actually two types of drug testing statutes in Utah. There's one that applies to all employers except governmental entities. And there's a second drug testing policy that applies to governmental entities. For private employers, this has no impact on that statute. For local government entities, there has been a change. So under the private entities can essentially adopt a policy, any policy they want, so long as it's consistent with the, well, they can actually, let me explain that better, and I'm sorry. Private employers can have any type of drug policy they want, whether it's compliant with the statute or not, the Utah state statute. If it complies with the Utah state statute, private employers get benefits from applying, for complying. They get protections from liability that they would not otherwise get for their drug policies. So it's not a mandatory requirement that private employers comply with the drug testing policy. It only provides benefits if it does with the state legislation. Local government entities, in order to do their drug testing, they have, of course, constitutional requirements, but they also must follow the local government entity drug-free workplace policy. They're required to follow it in order to drug test. The interesting thing about the previous, before this amendment, the interesting thing about the local government entity drug testing statute was that it allowed for any type of drug sample to be taken by a local government entity. But because of a quirk in the way the statute was written, if a local government entity wanted to discipline an employee based on a drug policy, a drug test, they had to use a urine sample, because the statute said an employee, before being disciplined, had to have the opportunity to have their split urine sample tested by themselves. They could have it tested. So the only way a local government entity could discipline was to use a urine sample, even though the statute permitted any type of sampling that was essentially scientifically sound. This statutory amendment requires a local government entity to adopt certain provisions that it didn't require before, but now requires, but more importantly, permits discipline based on other than a urine sample, but the law says, and I'm quoting, it allows discipline based on an oral sample. But here's the problem. I don't know, and I don't think anyone knows what oral sample means. Oral sample could mean breathalyzer. It could mean saliva taken from somebody's mouth, but there's no definition of oral sample, and it only says oral sample. So the other question is, why would they have expanded this definition to include oral sample, but why wouldn't they allow, for instance, if somebody had done a drug test using blood? It doesn't permit that either. So expanded to oral samples, but it doesn't define oral sample, and it excludes other types of testing before discipline can be taken. So that being said, key actions for governmental employers. They should evaluate their personnel policies to ensure that they do not violate the Act, make sure the Act is compliant with the new requirements that have been placed within on policies. And secondly, they should adopt policies to allow for discipline for, quote, oral samples in addition to urine samples. Of course, the unresolved question is, what does an oral sample mean? I think realistically, you could define your policy to include then breathalyzer tests, or also tests conducted by taking saliva for somebody's mouth. I think those would probably meet that standard, but it's not at all clear that they would. So hopefully we'll have some legislation that actually just says, and my recommendation would be, any scientifically approved method of sampling can justify discipline if it shows that there's some violation. And so those are all of the important pieces of legislation that apply generally to either local or, governmental employers or private employers. But we have a list. We have listed all 72 different pieces of legislation that might impact you as an employer, particularly if there's some specialty. And we've provided that, and we've done it by topic. And we should have those materials available to anyone who would like them. And if you, I'm sorry. And anyone who's registered for this and who's watching this, we will make sure that we send you a copy if you request it. Are there any questions? Now, I'll just open it up for questions generally. We'll sit here for a few minutes and open it up for questions. Any question? Even if we didn't talk about a particular piece of legislation. No questions from the floor. Doesn't look like, appears there's not going to be any questions from online. So we just thank you for participating in this this seminar. We're happy to answer any other questions if you have any that arise after you're done, and maybe you didn't think about them at the time, but we're happy to have you reach out to us and respond to any of your questions. Also, if any of you need particular help, please contact us if you would like us to review policies to make sure that they're compliant with the statutes we talked about. We're happy to do that as well. And thank you again.
When you're lost in a world of legal war, you don't know which way to go. There's a hero waiting with expertise to lend. The Utah employment lawyer, HR's best friend. Oh yeah, he's the advocate of the office, the guardian of rights, fighting for justice in the darkest of nights. When you're caught in the HR maze, feeling all alone, he's the ally you need to make your troubles be gone. Oh, the Utah employment lawyer, HR's best friend.